executive director. We're an affiliate that's been around for 75 years. We're the 5th oldest affiliate in the country, and we just celebrated that last year. We're looking forward to this evening. We're going to be having a good speech by Sharon Malheiro, who's the founder of One Iowa, which is a really terrific organization that's stood up for equality here in Iowa and human rights for gays and lesbians. And we're also going to be awarding the Louise Noun Civil Liberties Award to the 3 justices who were unfortunately removed by the voters last November, and recognizing them for their contributions to freedom. And it's going to be a great evening. We're looking forward to it.
Thanks everybody for coming. And I'm going to start off by introducing elected officials who are with us tonight. It gives me a great deal of pleasure to do this. State Senator Herman Kornbach. Welcome. And State Senator Joel Bolcom. And State Representative Mary Marcia. And former State Rep and Mayor of Cedar Rapids, Kay Halloran. She was here. And our Representative David Loebsack was with us earlier. The Hawkeye Board meets every other month. We have discussions of civil liberties issues in the area. We pay attention to problems that are brought before us. This year, of particular interest was were questions about the Iowa City Police Review Board. Our history with this organization goes back several years when the Hawkeye chapter, and particularly one of our members, Carolyn Dieterle, was very instrumental in getting us on the ballot and having a police review board created in Iowa City. This year we were interested in creating greater openness and access in particular to data from the Police Review Board. One of our board members, Peter Hansen, tells me that I should call this a work in progress. We continue. We have an election going on. The results will be known after May 4th. This was complicated because we created a board with staggered terms. What I'm going to do is introduce the members of the board and the candidates who are here tonight, and then I'll read very briefly those who are candidates for election who are not here. So, Dean Abel, and would you please stand, and we'll have applause after I'm done. So, Dean Abel, Evan Fales, Dave Muller, Steve Polsdorfer, Carolyn Dieterle, Rebecca Ryder, and Peter Hansen. Now these are the candidates for the election that is coming. We actually were fortunate to have a very full slate. One of the members of the board told me that this is a very peculiar election and that those on the board were recruiting people to run against them. That's the way that, maybe that shows our commitment to democracy. Wendy Barth, these are candidates who are not here tonight. Wendy Barth, Barbara Beaumont, Gary Goosen. Oh, she's here. Sorry. All right, now tell me if I'm wrong. Gary Gusson, Darrell Lipscomb, Nathan Handler, and Steve Hankin. And these are the candidates for the election. That, thanks to the good offices of Peter Hansen, is going to be finished, we hope, by May 4th. All right, now I'm going to turn matters over to Sally Frank, who's president of the State Board.
There's a height difference. Thank you, Bob. On behalf of the State Board, I want to welcome all of you here and thank you all for coming. This is a very exciting gathering for us every year, and we're so glad that we can do this with the Hawkeye chapter. I'd like to introduce to all of you the members of the board that are here tonight. We had more people at our board meeting earlier today, but some just were unable to stay. As I call your name, please stand, and then when we're done, we can applaud everybody. Eddie Broders, Rachel Garst, Shans Gonin, Scott Hartzog, Art Heiderman, Dave Muller, Judith Hunter, Alex Orozco, Janet Rosenberg, and Sandy Vipalka. Did I miss anybody? Thank you all. I do want to take this opportunity to mention one board member who could not be here tonight. He was our president last year, Nick Dries. He is very ill at this time, and all of our thoughts and prayers are, well, those of us who pray are prayers. Those of us who don't, this is the ACLU, our thoughts are with him, and the board did pass a unanimous resolution that will be giving him of our support and admiration for the work that he does and has done, and we're hoping he'll be back with us again next year. We also have many former board members who are here tonight, and I don't want this evening to go on for hours with naming names. So if all of the people who have at any point served on the board of the ACLU of Iowa would please rise, we'd like to recognize you and thank you. There are a couple of other people I want to specifically recognize. With us tonight is Dan Johnson, who was the attorney in our famous Tinker case, and I believe is still practicing. He's back in Iowa, and we're glad to have him here. And Ann Boberg. Sorry, I'm not good at pronunciation. She is not on the board, but has done amazing service for us for the last 3 years being one of the non-board members of our nominating committee. And so we want to introduce her and thank her for all of her work. And now I'm going to turn the program back over to Ben Stone. He introduced the program but did not introduce himself. Ben Stone is the executive director of the ACLU of Iowa and one of the longest serving executive directors in the ACLU now. Every year he moves up on the ranks of long serving. We are extremely lucky that we have him and have been able to keep him all these years.
Thank you, Sally. I think I'm 14th in the rankings for executive directors. Ramona Ripsman has run the Southern California affiliate for 35 years. She's retiring, yeah, I know, so long way to go. I'm going to briefly speak about my wonderful staff, give a very brief update on our activities affiliate, and then I'll be introducing our keynote, Sharon. And then we'll finish with the Louise Noun Awards. Last year at this time, I had 2 staff on top of, in addition to me. We now have 5. And there are many people in this room that are responsible for helping to make that happen. And I want to thank you I've tried to do that individually in writing, but I also want to do an opportunity here. We had an amazing fundraising year, and it is because of that I can introduce my two new staff people. First, I will mention the staff that were here before. Ellen Simmons is over there. She's, of course, my executive assistant, and she's very involved in our development work. She's been with us for 5 years. And Randall Wilson is not with us tonight. He is in Louisiana at a wedding for his family, kind of a reunion type of thing. So he could not be with us, but he certainly wishes he could be. Randall's been with us for 23 years now. He's the second longest serving legal director in the country, so we've got longevity here. The new staff, I'm going to start with Veronica Fowler. Where's Veronica at? There she is over there. She joined the staff last summer, and she was lucky enough to join the staff right as we were getting ready for the 75th anniversary celebration, which was not a lot of work anyway, so she had nothing to do. But no, she came just in time and helped us manage to pull off that event. Those of you that were there last fall over in central Iowa, we had a great time, and we still got 75th stuff, so take all you want. We've got plenty of it. Veronica is from Ames. She lives in Ames and commutes down. She worked at the Des Moines Register as a journalist for several years, and she also worked at Meredith in the publishing, and she runs the Iowa Gardener website, so she's a good gardener resource. I wish I was a more active gardener. I'd be exploiting her viciously. So she's been with us since last July. She's our communications specialist, by the way. I didn't mention that. So she's helping us get much more vigorous in our communications efforts through social media and the internet and email and the website and press releases and calls from reporters and everything. Op-eds, you name it. She's doing a great job. We're really glad to have her. She actually interviewed me when I ran a student association many years ago in the early 90s. And I remember her. The other addition to the staff came just last winter. Anna Day is our staff attorney and legislative lobbyist. For those of you that check our emails know that I actually hired somebody in January, and she didn't work out. There were some personal problems that happened, and she had to resign. So I stayed behind from going to a staff conference and started looking through emails, and there were emails that had come in after I had offered the job to this other person. It's like, wow, there's some good people here. And one of them was Anna. Anna's originally from Fairfield, and she has a law degree from Seattle Law School, and she's been doing a lot of research. She worked with Angela Campbell and Gary Dickey. You may remember Angela Campbell. She is the attorney who was at our conference several years ago who represented people at Guantanamo Bay, Cuba. And so she came, and Angela gave her a glowing recommendation, and I'm just thrilled. She came into the legislature in the middle of February. And of course, Joe, there was nothing going on then, right? It was not busy. Plenty of time to just kind of coast in, not busy. Boy, she just, no experience lobbying, but I could sense that she had the personality. She would just step into that rotunda, not be intimidated by anybody, would be able to talk to people and get to know people, and she's just, all reports are that she's doing a fabulous job. She's really bright, and we're delighted to have her, and I want you to get to know her. She's a fine addition to our staff, and I've told people that she's smarter than me, and that's really good. And it's because of the support of people like you that we can do this. Now, what have we done in lately other than having a very vigorous presence once again up at the Capitol? We won our lawsuit last fall against Davenport on the parental responsibility statute. I'll go into this a little bit later. That those victories are not all that often. I'll do that in the context of our Noun Award presentation. But anyway, so that's good, and I believe that they're fighting with us on attorney fees, which Davenport always does that. I don't know why, because we've always been on the attorney fee arguments, and that just increases the attorney fees because the arguments you get reimbursed for. So if you live in Davenport, tell them to calm down and just recognize that they were not the prevailing party, and we don't charge ridiculous amounts of time. So Randall's been dealing with that. But it's been a very exciting year. we're going to be kicking off, we've been developing a open records program on our website. Those of you that follow these things know that the legislature has had a very hard time resolving how to make our open records, open meetings law more vigorous and more useful for the members of our public to be able to know the transparency of their local governments and school boards and everything. So we're working with the Open Meetings and Open Records group at Drake, and we're going to be setting up a website that's kind of a resource for Iowans to learn how to do an open records, open meetings request. And so we're doing that. We've also got a student rights handbook that's very close to being finished. We've been working on that for a couple of years to help the youth of the state understand they've got very good, powerful rights that were passed years ago and that the Supreme Court of Iowa has endorsed. So a lot of things going on, and we've just got more coming because we've got 5 staff now, and we've got a lot of ambition, a lot of energy. And before I introduce Sharon, I do want to say this. We mentioned that Ann Boberg has been great on our nominating committee. We are looking for excellent, fine, committed civil libertarians who would be interested in serving on our affiliate board. And if you have any interest in that, please let us know. It's a lot of fun. There's obviously a lot of people in the room you can talk to about this, but particularly in the college towns, Ames and Iowa City, we would appreciate anybody you can recommend to us, because obviously the staff have no way of participating and doing our jobs if we don't have a board that is out there. Without a board, there is no ACLU of Iowa. It's entirely dependent upon our lay leadership. So make that pitch for you. Our keynote tonight is Sharon Malheiro. Now, those of you that have paid attention to the struggles for human rights in Iowa for the last, I'd say at least the last 10 years, visibly, Sharon's been a part of that. She's been a pioneer, a real trailblazer as an attorney working on human rights for LGBT and transgendered people in Iowa. She is the second female president of the Davis Brown Law Firm. She is a Drake Law graduate. She worked at the Des Moines Register as an editor prior to going to law school, so she's got a journalistic background. And she's originally from Chicago. She's an Iowan by choice. And she is one of those people, along with her wife, Sue, who have taken advantage of the Varnum v. Breen decision. And I've gotten to know Sharon. I serve on the board of One Iowa, and Sharon is the chair of that board. And it's been a pleasure serving with her and getting to know her. She was very much involved in the Lambda legal case that became Varnum v. Breen, and she'll be speaking to some degree about that. And I am very pleased and honored to introduce Sharon Malheiro.
Thank you, everybody. Thanks, Ben. I'm honored to be here tonight. The ACLU is a great organization, and thank you for all the hard work that you do on behalf of Iowans. Before I begin tonight, I want to first publicly thank Justices Ternus, Streit, and Baker for your hard work and your service to Iowa. Some of the behind-the-scenes issues in the Varnum case that people don't know, probably the secrets that we had. One thing I wanted to say first is Chief Justice Ternus went to great length to make the Varnum case open to the public, and people don't realize that. She created a web page on the Supreme Court's website so that you could access all of the Varnum documents. When it came time for the oral argument, knowing that many would want to hear this, she made sure that it was televised, and we have watch parties all across the state, and I know that those arguments were watched nationally and internationally. And had it not been for her, we would not have been able to see that. And I also think that it helped with some of the safety issues because there weren't people rushing to get to the courthouse to have a seat because you knew that you could sit in your home and watch those. So I think people need to know that. I also think people need to know that Iowa's Supreme Court is the best in the country, and I'm not prejudiced. Many people do not know this, but often Iowa Supreme Court decisions are used by other appellate courts across the country for analyzing their own legal issues. They're using our decisions as their precedent for making change, and I think we should all be proud of the work that our Supreme Court does. So, I'd also like to recognize two really good friends of mine, Trish and Kate Varnum. Katie. Only your mom does. They're the Varnums of the decision, and they're here tonight with their mom, Liz Varnum. So, they asked me to talk tonight about the history of the Varnum case. It all began in the late 80s when the gay and lesbian community began to organize and become more politically involved in issues that related to discrimination and civil rights. As the community came together and began to actually come out and seek equality in the areas of housing and employment, many state legislators felt that we were also going to seek equality in marriage. And I'll be honest with you, we never thought about it. We never thought marriage was going to be an opportunity for us. We just wanted to not get fired from our jobs or thrown out of our houses. So Vermont took the first step by allowing gay and lesbian couples to create a civil union as a way of deflecting a potential marriage issue. Other states, however, took a more drastic step, and they began passing defensive marriage laws, or DOMAs as we call them today. In reaction to these DOMAs, several national civil rights groups, including the ACLU and Lambda Legal, began to research and analyze the constitutionality of the DOMAs. As often happens with gay and lesbian civil rights matters, the focus went to making challenges in California or New York, because everybody thought that that's where the only libertarians were California or New York. And they believed that Iowa was merely a flyover state. Iowa's DOMA was passed in 1998. At that time, I began to lobby Lambda Legal to bring a lawsuit in Iowa. I've been working with Lambda Legal for several years on issues relating to transgendered Iowans and creating gay and straight alliances in high schools. That work was difficult, and the treatment that we received in those issues made them think that maybe our court system would not give us a favorable result. So I continued to lobby. I brought Iowa's rich history of being a front runner of civil rights to their attention. At the same time, a lesbian couple in Sioux City sought to have their Vermont civil union annulled. The district court judge, using his power of general jurisdiction in civil matters brought to him by Iowans, annulled the civil unions. Somehow, this discrete, isolated decision came to the attention of several Iowa legislators. And we've never been able to figure out how they got this decision, but they did. They then filed an action before the Iowa Supreme Court to have this annulment reversed. The lawyer who brought the original case refused to defend it. I think he was afraid of some political ramifications. So I called Lambda Legal and said, hey, let's do this together. And they said, okay. The case, Allons versus Woodbury County District Court, and the Iowa Supreme Court's decision sealed the deal for Lambda Legal to mount a challenge on marriage in Iowa. However, before they would really file it, we had to read every case decided by the Iowa Supreme Court on the Equal Protection Clause. That was a challenge. One of the most persuasive to them, though, was Racing Association of Central Iowa versus Fitzgerald, or as we call it, Racy 2. That decision was authored by Justice Ternus. It had a wonderful constitutional analysis in it, and it made them think that this is the way we could see our argument going. Over the years, many couples had approached Lambda Legal about representing them in a marriage fight. So the next step was finding the couples to make the challenge. We knew that our opposition would highly scrutinize these people and would bring them up to whatever they had done. So there were FBI searches done on every couple. There were criminal background checks done. And there were many, many meetings. And you two can attest to this, where we said, you sure you want to do this? This is really going to be ugly. You're going to be in the public. You're going to get hate mail. You're going to get all kinds of pushback. And we were fortunate to have 6 brave couples agree to sign on to the case. We knew that in addition to great legal work, though, we also needed grassroots organizing. Our strategy was to caucus the issue of civil marriage the same way we caucus for presidential candidates. As a result, One Iowa was formulated, and we spearheaded the effort to bring the issue of what civil marriage meant to everyday Iowans. Every day we went out and we tried to change the hearts and minds of Iowans one at a time about the issue of civil marriage equality. We recruited Iowans from every corner of the state to work at talking to their friends, their neighbors, and their families about why this issue is a basic civil right and it's an issue of fairness. Our philosophy was, somebody from Des Moines can't go to Decorah and say why this is a good thing. We had to train people in Decorah to say why this was a good thing. So caucusing the issue was our goal. Back to the case, during the discovery and research phase of the case, the Washington Supreme Court ruled that marriage rights for same-sex couples was not necessary because same-sex couples cannot procreate. And it's an issue of procreation. Fortunately for us, 2 of the plaintiff couples had children. So to counter that argument, we moved to amend to add the children as parties so that we could argue on their behalf as well as on their parents' behalf. The amendment was granted. One of the more critical parts of the case was organizing the amicus briefs. Those are the friends of the court briefs that actually give a little more social inspect into the case as opposed to just the main legal issues. We knew from prior cases that the opposition would file these briefs, and we knew that we needed our own set. 25 amicus briefs were filed in this case. We had more than they had. The best one was what we call the courage brief, and that brief outlines Iowa's rich history of civil rights. And if you can get a copy of that brief, it is an amazing brief to read. It was very well done, and it just says it's on your website. I think you can probably get it off the Iowa Courts online too. But it's an amazing brief, and it's an easy read, believe it or not. Discovery was also a challenge because the opposition designated many expert witnesses. Sometimes I think that was in an effort to break the case financially, because Camilla Taylor had to fly to England to take the deposition of one of their child welfare experts who was testifying that children would be harmed if they were raised in a same-sex environment. But Camilla got that. She was taking the deposition of one of their experts in Washington. A lawyer from Focus on the Family came in and said he was there to help with the deposition. And Camilla said, Focus on the Family is not part of the case. They're not a party to the case, so I'm not going to let them be in the deposition. Now, legally, could they have been in the deposition? We probably could have lost a fight if we went to a judge on that, but the county attorney relented, although he was really reliant on this particular lawyer to help him with the questioning and the objections, but he didn't get to participate, so he sat outside the office all day and wasted that plane ticket to get to Washington from Denver, so we were kind of happy about it. As we prepared for oral arguments before the Supreme Court, plans were also underway to prepare Iowans about the rights and responsibilities that marriage brings. We did not want a rush to marry only to result in an avalanche of divorces. And I'm proud to say, gay and lesbian couples are approaching the issue of marriage with all seriousness. there have been no 24-hour Britney Spears marriages that I'm aware of. Prior to the argument, there were many days and nights spent moot courting Denny Johnson. And the day of the argument, he was amazing. 2 days before the decision, if you haven't ever seen, I don't know if they have the tape anymore, but he was amazing in his argument. He was calm, cool, collected. I think he did a wonderful job of representing the plaintiff couples. And 2 days before the decision came down, we got a call from the governor's office telling us that the Supreme Court called and wanted extra security on Friday. It's like, hello. So we knew that Varnum was coming down that day. And we all got ready. I had a judge from Polk County call me and say, oh, Sharon, I'm so sorry you're going to lose. And I said, why? And she said, they surely would not issue this decision while the legislature was still in session and allow you to win. And I said, Judge, do you think the court's that politically motivated that they would hold a decision withholding constitutional rights until they thought that the legislature was out of session? Well, I just think you're going to lose. And we did not. Lambda Legal brought all the couples to Des Moines and sequestered them at the Hotel Fort Des Moines. We had people at the courthouse at 4:30 in the morning so that they could be the first in line because we wanted to be there before the bad guys. So, to get the opinion. Camilla and I were at my office, and fortunately we got on the website and got the opinion before the court server crashed because there were so many hits at that time to get a copy of that decision that the server crashed. And immediately we went to the last page. It said, affirmed, all justices concur. And that's all we needed to hear. Not to diminish the beauty of the opinion, but anybody who's a lawyer knows that when you get a decision from an appellate court, the first thing you do is flip to the last page because you want to know if you won or lost. My staff said they had never heard such a loud cheering coming from my office. Immediately, Camilla Taylor went across the street to the Hotel Fort Des Moines where the couples had been waiting. They didn't know the decision. And we had them in a private room. Camilla walked in, got up on the stage and said, we won. And you've never seen so many tears of joy come out at that time. And so much hugging and love in the room. It was an amazing experience to watch these people who had been through this together for 2 years be together to hear the decision that was going to allow them to get married. For those of you who have not read the decision, I encourage you to read it. It is a well-written constitutional analysis. It's also an easy read. But I also encourage you to read Judge Hanson's decision at the district court. It too was a well-written and thoughtful piece. And for those who don't quite understand legal procedure, Judge Hanson could have issued his decision by saying we won on one argument. And because we won on one argument, he didn't need to go into all the other arguments were made. But instead, he took the time to rule on every argument that was made. And as a result, I think it made our effort on appeal easier because every argument was addressed. There wasn't an issue to argue to say, well, to the Supreme Court, well, he didn't talk about this, so let's not talk about this. He talked about every argument that was made, and he did a very thorough and I think wonderful analysis of it. He will tell you that he barely passed constitutional law in law school, but you can't tell it from reading his decision. The one regret I have, though, is that we were not able to defend the justices in the judicial retention election. And that will always be a dark spot in this otherwise triumphant victory. We just celebrated 2 years of Varnum. When we began the case, more than 60% of Iowans polled did not favor same-sex marriage. In a poll conducted this January, more than 60% of Iowans polled said that same-sex marriage does not deserve the legislature's time rotation. So we clearly have changed hearts and minds in Iowa. A 78-year-old woman was asked recently about her opinion of same-sex marriage, and she said, I don't really know. I was married 3 times. So I don't really think I should have an opinion. And to me, that sums up Iowans. And that is why I knew that Iowa was the place to bring this challenge, because Iowans will believe that. Varnum will now join Iowa's commitment to protecting the equality of individual liberties for all Iowa citizens and challenging private prejudice and arbitrary public restraints on individual dignity and accomplishments. Iowa has not been content to await the word of federal courts, the deliberations of sister states, or the safety of national consensus. 26 years before the United States ratified the 13th Amendment, Iowa's Supreme Court declared that no man in this territory can be reduced to slavery. Nearly a century before Brown versus Board of Education, Iowa rejected separate but equal for African American children in public schools. Iowa was the first state to admit women to the practice of law, and Iowa is the home state of the nation's most heralded advocate of women's suffrage, Carrie Chapman Catt. And now Iowa is the first state to judicially recognize the rights of all to civil marriage. So I thank you for your time. For questions, if you have any questions about the case or what we did or what we didn't do or how many martinis we had at my house, talk about strategy, I'd be happy to answer them. The spaghetti dinners too, yes.
A strategy question. It seems to me the Iowa State Bar Association dramatically dropped the ball on retention. And as near as I can tell from talking to your partner, who's the president of the Bar Association, we're on the course to repeat the mistake that we made before. Any thoughts along those lines?
The question has to do with what efforts the Iowa State Bar Association took on behalf of the retention election and conversations that you've had with Frank Carroll, who's the current president of the bar, that we're on course to repeat it. I agree if we let Iowa lawyers run this. Iowa lawyers shouldn't run it. People who can advocate and talk to other people should run it. Iowa lawyers are used to talking to judges and juries. And so we talk lawyer speak. And I think you have to have somebody, Bob Vanderplaats is passionate. He's got buzzwords, he's got all kinds of stuff out there that he can say. Now, Iowa lawyers will say, man, I don't know if I can say that might not be appropriate, you're gonna get sued. Where Bob Vanderplaats can say whatever he wants and he doesn't care. Because Iowa lawyers have this little license that they're worried about losing. And so I think that a campaign on judicial retention cannot be run by lawyers. It needs to be run as a political campaign, just like any other campaign that we run. And that's my opinion, not the Bar Association's.
I don't actually have a question, but I just wanted to thank you because I came late this evening because two of my dear friends were able to get married tonight after 17 years together. So I thank you very much.
Any other questions? All right, thank you.
I've learned over the years I need to check my list. Make sure that I don't forget too much stuff. I always forget some things, but by the way, thanks, Sandra. I did want to ask earlier, are there any members of the Fourth Estate here? Any people consider themselves journalists? All right. Their loss. Their loss. All right. I have to say, folks, and this is something that Sharon shared as well, it is absolutely tragic that we are here tonight. It is absolutely one of the most regrettable and shameful things that has ever happened in the state of Iowa. That the people did what they did at the polling place last November. Frankly, most of us in this room shouldn't even know these fine justices very much, because they should be doing their job. They should be back with their families tonight, not coming to events like this, because judges don't do that. But that's not what happened, and we're honored they're here, and we hope that our little acrylic awards can help just a little bit. Those of you that get the legislative alerts that Anna Day has been sending out, she found a terrific quote, I think it was last week, and I'm just going to start off by reading that. This is from Alexander Hamilton, one of the authors of the Federalist Papers. You might recognize him. He's kind of an important guy back a couple hundred years ago. There is no liberty if the power of judging be not separated from the legislative and executive powers. That is the essence of it. That is as true today as it was in 1789, or whenever he said it. The only way that individual equality, individual rights are protected from political tyranny, executive or legislative, is from judges. Back in 2007, there was some news coming out of Pakistan. Remember this? Lawyers were fighting in the streets, getting killed. I mean, lawyers were rioting. Any lawyers in here? Have you been rioting lately? Sal, you come close. And you know why these lawyers in Pakistan were fighting in the streets? It was to protect their judges. Because you know what? The greatest plaintiff attorney on the face of the earth doesn't have a chance to do anything if there isn't a judge. Without judges, there can be no freedom, there can be no liberty. When I was in law school, I started in the fall of '93, and that same fall, the Hawaiian Supreme Court ruled in a case called Bayer v. Lewin that same-sex couples under the Hawaiian Constitution had the right to marry. So my very first assignment as a law student to write a paper was about marriage equality, civil marriage equality, same-sex marriage. And I'm reading this, and I'm thinking, God, this is, it's so obvious. This isn't going to take a whole lot of time. And that was 1994, and then just year after year, because my opinion was that there really wasn't any valid, empirical, logical, material reason to create impediments to same-sex couples to marry. Just, strict scrutiny, hell, intermediate scrutiny would get it for me, okay? But anyway, so I'm thinking, well, it's kind of self-evident, right? Remember, self-evident, that's the rights we have in the Declaration of Independence, right? So it was self-evident. But year after year, judges around the country kept, I think most of them, I don't know them, but most of them, I think, they were engaging in fantasy. They were finding that there was validity to arguments that, unless they themselves had that same particular religious perspective, in their heart of hearts, they had to know that they were simply dodging the issue. And so 10 years go by, that was 1994, 1993 when the decision came out. Finally, 2004, Massachusetts. Well, good for them, but that's Massachusetts, right? What do you expect? They've got this little, it's almost like Johnson County compared to Iowa, right? And then a couple years later in 2006, California. And, but in between all that, there was, I don't know, probably a dozen cases, including a lot of district court decisions, where the judges just didn't step up. They were just not ready to take that stand. And then in 2007, Judge Hanson in Polk County, he didn't pass the buck. He didn't just, deny the equality argument and let the Supreme Court take the heat. Judge Hanson stood up, which is really amazing. I don't know how many district court judges did that across the country. I don't know what the percentage would be, but it's not usual because he was willing to take some heat. And perhaps his courage set an example. And then in 2009, the Varnum decision came down. And as Sharon mentioned, the Supreme Court of Iowa has a very long history, an amazing history. That the Courage Brief, it is a good read. I do encourage you to read it. That hopefully inspires some of this. But you know what? It's not popular. Well, gee, what a surprise. A judge does something that isn't popular. Well, I'm only going to give one example of an unpopular decision. And it happens to be an ACLU case, so I'm a shameless promoter, so excuse me. Loving v. Virginia, 1967. ACLU case, interracial marriage, U.S. Supreme Court. Overturned the Virginia statute that completely forbid people of different races from marrying. A poll by Gallup in 1968, just months after this decision, found that 73% of Americans disapproved of interracial marriage. Okay. So that's almost 3 in 4, folks. That's unpopular. So, if at that time there had been the ability, and there is no ability still, federal judges, thankfully, have life tenure. And you remember back to the Brown versus Board of Education, those of you know your history, that the Brown decision from the Warren Court engendered, impeach Earl Warren, get rid of the justices. So there's a long history of animosity to leading decisions. But that is the role that judges play. Independent judiciaries are absolutely essential to the work of all kinds of organizations. I guarantee you, in 1909, the NAACP would not have formed if it wasn't for the fact that they thought they could convince judges to stand up for equality. The ACLU was founded in 1920, same thing. Until the ACLU came along, no federal Supreme Court decision had mentioned the free speech clause of the First Amendment favorably. I mean, it took it until I was like 1929 or something before the Supreme Court actually ruled in favor of overturning an action of the government for a free speech violation. So judges they have a solemn duty to our society. The world we live in today would be drastically different if everything that flowed into our society and out was based on political popularity. And this is the only mechanism for values that, hopefully eventually overcome. And right now, only 17% in 2007 poll, only 17% of Americans disagree with interracial marriage being okay, disapprove of it. So it's a huge change.
Yes.
But where would we be today if the court hadn't made that ruling? I mean, things are not inevitable. It just doesn't happen that way. It is just quite simply an essential truth that what judges do for our civil society is something that very few people appreciate. And Bob, in kind of an answer to your question, we've been active in justice, not politics. And it is a struggle. The 501c3 groups that made up that initial coalition, none of us could say yes. We could not say, vote yes for these people. We're all 501c3 organizations and there's rules against us doing that, including ACLU has internal rules. So it was very frustrating. You may remember that it was only 9 days before the vote that a group organized actually said yes, whereas Vanderplatz and these people were saying no for several months, since August. So it's a very frustrating situation, but there is organizing going on. Money's being raised to try and create, and what is happening is that when you do see Vanderplatz and other people making comments, there's a response. That day, Aaron Seidler is the main point person, and again, Jordan Oster, they work for Justice Not Politics. It's a coalition that's being underwritten by several groups. And they're their response, so the playing field isn't left to the Vanderplatz of the world. So But what will happen with Justice Wiggins, I don't know. And before I do announce the justices and present them with their awards, I do want to make one final point. And that is that it's not just the fine job they did as judges and their ability to stand up for things. It is also the way that they conducted themselves professionally in the midst of all this. They didn't go out and politic. They didn't go out and, for the first time in the modern era, since the 62 amendments, go through the process of arguing for themselves that they deserved their job. They just kept doing justice. And it had to be hard. I mean, only they know, and maybe they'll speak to that, I don't know. But the way they conducted themselves while they were being bashed and bullied and their faces were on this god-awful bus. We used to call it the hate bus. The hate bus tour. But anyway, and that's a part of this as well. So the ACLU of Iowa is presenting, the Foundation of Iowa is presenting this award to Justice Ternus, Justice Streit, and Justice Baker. And I'm going to finish with this comment. We went back and looked at our cases going back to '93 when you joined the court, Justice Ternus. This is not about awarding people who always do what we want. That's the point. Judges are not there to please you. They're not there to please us. We won 36% of our cases since 1993 to the Iowa Supreme Court. If we had the values of the opponents of these justices, there's no way we would award them because they didn't agree with us enough. But I don't know how to more clearly demonstrate that it is about defending equality and the rule of law. That's their job. And if they don't agree with any of us, it's our role to understand that and defend the process so that justice has a chance in the future. So we've got 3 of these. I'm going to read one of them, and then I guess you can 3 come up and you can decide how you want to proceed in terms of speaking. But this is the ACLU Foundation of Iowa presents the 2011 Louise Noun Civil Liberties Award to the Honorable Justice Marcia Ternus, Michael Streit, and David Baker, for continuing the proud tradition of the Iowa courts in steadfastly upholding equality, judicial independence, and the rule of law. Please give a solid round of refreshment for these people.
Surprise, and I know disappointment. I'm not going to make any kind of speech. Justice Baker and I decided that our chief should speak for the 3 of us on thanking you for this considerable award. We value it. We're honored by it. Thank you very much. And Chief Ternus will extend a more thorough thank you.
My colleagues and I are truly very, very honored to receive the 2011 Louise Noun Award. Louise Noun, as everybody in this room knows, was a steadfast defender of civil liberties and undertaking in complete harmony with the mission of the ACLU to defend and preserve the individual rights and liberties that the Constitution and laws of the United States guarantee everyone in this country. Of course, to achieve this mission, the ACL frequently turns to the courts, and of course Louise Noun supported that, and I'm thinking of Dan's case, Dan's case, the Tinker case. Oh no, I'm only going to say good things. Which of course went all the way to the United States Supreme Court and resulted in a landmark decision upholding student rights. And like the ACLU, our founding fathers understood the role of the courts in protecting civil liberties and civil rights. Alexander Hamilton said, and this is close, I think might be the same quote that Ben used, but Alexander Hamilton said in the Federalist Papers that without the power of the courts to declare acts of the legislature contrary to the Constitution, the rights and privileges reserved to the people would amount to nothing. Hamilton also recognized that an independent judiciary was necessary to guard the rights of individuals from oppression by the majority. Even though Hamilton made these observations over 200 years ago, they certainly ring true today. Unfortunately, the independence of our courts is being threatened by the intimidation of special interest groups, political pressure from the other branches of government, and in some states, the influence of campaign contributors. I want to take this opportunity to thank the ACLU for not only recognizing the importance of a judiciary independent of political intimidation and influence, but also for actively resisting efforts to politicize Iowa's merit-based system for selecting judges. It is the responsibility of this generation of Americans, of everyone in this room, to support and advocate for a judiciary with integrity, one free from politics and political elections, free from intimidation by special interest groups, and free from the influence of campaign contributors. The time has come for all of us to take a stand against the politicization of the judiciary in Iowa. When the three of us took our positions on the Iowa Supreme Court, we took an oath that we would uphold the Constitution of the state of Iowa and without fear, favor, or hope of reward, administer justice equally to the rich and the poor. In rendering our decision in Varnum, we simply followed our oath of office and upheld the supremacy of the Iowa Constitution, which guarantees all citizens equality under the law. It is not often that one receives an award in large part for simply doing one's job as one should. So in some respects, I think we all feel a little undeserving of this award. Nonetheless, we are proud of the Varnum decision, which was grounded solely on what the Constitution demanded. And we are proud of the character exhibited by the 7 justices who participated in that decision. So it is with a mixture of great humility, but some measure of pride, that we accept this wonderful award from the ACLU. Thank you very, very much.
Thank you. Thank you. We have a little time, and I've had a request from Dan Johnston to give him, like I said, the rebuttal. And I can't say no to Dan because he won the biggest case that I ever get to talk about in the ACLU of Iowa. So Dan has some comments he'd like to make, and we have time. So, by the way, is the cash bar going to stay open for a while? It's all done? Okay. All right. Can you open it back up? You can? Okay. All right. I tried, folks.
Justice, I realize you feel you were only doing your job, but after 50 years of practicing law in the state, I have to tell you that I could recite a number of instances where judges did not do it. The reason I wanted to say something is that in 1965, at a place less than a mile from here, After flirting with each other in law school for 3 years, Norman, Jesse, and I became lovers. A year later, I was elected to the Iowa legislature, and Norman and I were still lovers. 2 years later, I was a Democratic nominee for Attorney General, and Norman and I were still lovers. And that same year, he was elected to the State Assembly, and he served there for 8 years, eventually becoming chair of the Judiciary Committee, and we were still lovers. In 1977, I became the Polk County Attorney, and we were still lovers. And I served there for 8 years, and we were still lovers. 10 years ago, 11 years ago at the end of this month, Norman died, and we were still lovers. But it was hard. God, it was hard. Because we knew that at any moment, the people who came after these judges could come after us. We knew we were goddamn good at what we did in politics. But we knew that at any minute, that can be taken away from us. And we feared it constantly, and it adversely affected our love as well as the rest of our lives. What these judges did, just doing their job, made it so much easier for Normans and Dans as they come along now to love the way their natures made them love and do their jobs the way they're talented to do. So thank you.
Thank you, Dan. There's no more poignant way to end it, folks. Thank you for coming. Thank you for caring about justice. Thank you for showing your appreciation to our honorees tonight. Thanks to Sharon for coming. And you know, in about, 16 months, there'll be a ballot issue, and Justice Wiggins will be on the ballot again. And let's all pledge to do everything we can as individuals. You see, we can't get involved in politics like that. Individuals, do what you can. And you know, you can educate people about the importance of what the judicial system is and the independent judiciary and retention votes, even if you work for the ACLU. And that's what we'll do. And thank you, have a safe drive home, and we'll hope to see you next year. Thanks.